Hello, everyone. Good morning to those we have on the West Coast. Hello, happy lunch to those here in the Central Time Zone. And good afternoon to those we have on the East Coast. I'm Katie Ilten, and today there are several of us who are going to talk to you about the opioid crisis response and the general things and topics we think that health lawyers and compliance officers should be aware of. We hope this is going to be helpful in aiding you all to do issue spotting for your organization, sort of educating you generally about how far states and the federal government have come in sort of tackling this issue. Before we jump in, a couple announcements. Next month in March, on March 11th, our webinar topic will be co-management agreements, gain sharing, those sorts of arrangements, and that will be presented by Marguerite Ahmann and David Glazer. So it's going to be a great session to talk about different options, enforcement and scrutiny of those types of arrangements, and then myths about those arrangements that we think are out there and you should be aware of about those types of arrangements. If you have questions, just remember to hover near the bottom of the screen. There's an option for a chat box. Your question will be anonymous to everyone else. No one can see it except us. We will try to take questions as they come if they fit in, and then otherwise reserve some time at the end. Speaking of the end, we are going to speak for probably about 90 minutes today. There are oftentimes we have folks asking for longer webinars. We thought this was a topic that warranted an additional time beyond the hour because there are just so many things to discuss. So hang on as long as you can, and we may talk up to 90 minutes here. We always want to hear your feedback. Please fill out the survey at the that you'll get a link to, I think, soon. And note that if you have a question you want to ask us in the survey or you want us to reach out to you, we do keep our survey responses anonymous. So we can't tell who you are unless you tell us who you are. So if you have a burning question, please put your email or phone number or name or both next to it so we can get back to you. Our team has really been doing a lot of work with different types of providers, startup companies, medical device companies, substance use disorder treatment providers, traditional hospitals, on how to deal with the legal issues that come up with respect to the opioid crisis. We have been doing work across states, and I think you'll definitely see today in this presentation that there are many state issues, and so we obviously can't go into every state's law and discuss them, but we've been certainly involved in sort of multi-state operations and responding to this public health issue. And we will send out some more information about what we've been doing in our follow-up to this webinar. And then finally, I'll say, remember that you can watch all of our webinars on our YouTube page, and there also you'll get a follow-up with the link to this, and you can forward it to anyone, and they can watch for free, and we won't even know who watched. So please take advantage of that resource. So just generally, I'm going to say that with the agenda, we haven't timed this exactly, but we hope to be kind of halfway through when we get to our Medicare, Medicaid reimbursement slide. So if you're taking a look and you don't have 90 minutes to commit, but you want to hit something, I think the halfway point hopefully will be right around that Medicare, Medicaid reimbursement, so you could tune in later if you want to tune us out at the beginning. All right, now I'll turn it over to Chelsey to kind of get us started.
Hi, I'm Chelsey Jonason, and I'm going to be talking a little bit about background and setting the tone for the presentation. So we know that the opioid crisis is regularly grabbing headlines as prosecutors are targeting pharmaceutical companies, the costs of the crisis continue to rise, blame is attributed to various parties, and people are continuing to suffer. So beyond the headlines is the very real human cost of the crisis, and the statistics help to tell that story and demonstrate the scale of the crisis. So from about 1999 to 2017, more than 702,000 people in the United States died from a drug overdose, and at least 2/3 of those overdoses were involving an opioid. So there's many reasons to believe that these numbers are deflated. as data regarding opioid deaths are often incomplete and outdated. Lack of reporting in opioid-related events due to fear of association with involvement in criminal activity also cause the numbers to not reflect the full story, and inaccurate and incomplete cause of death coding on death certificates and variation among how states code causes of deaths also lead us to believe that this number is higher than what's reported. So from 1999 to 2015, the growth of opioid-related deaths far outpaced the growth of non-opioid-related deaths. Also startling is that 41.5% of opioid-related deaths were attributed to prescription opioids. We expected the number of deaths related to illegal drugs would be much higher than they actually are. Rural states have been hard hit by the opioid crisis, and West Virginia, Ohio, Pennsylvania, and Kentucky present the highest death rates. But we also note that 23 states have, with various types of populations and economies, have also had statistically significant increases in overdose death rates. So we know that many of our listeners are in the challenging position of responding to the opioid crisis, and that you're all too familiar with the human stories that go behind these statistics. So up next, Katie's going to share some resources that we hope will be helpful to you.
So although it would be terribly interesting for us to research and talk about this topic today, we are not going to go into kind of the reason we're here, mostly because that's already been looked at. It's not really a legal topic, but there's terribly interesting sort of sources and story behind why this has become a problem. And I've been particularly kind of fascinated by this, and if you're sort of an investigative journalism junkie like I am, I've just put up a couple sources of background reading. I think if you're looking for something quicker than a book, the first bullet, the New Yorker article from 2017, is a really, really good narrative about kind of how the Purdue Pharma matter unfolded. That's the manufacturer of OxyContin and the family behind that company. That was a really, really good narrative, and I remember reading that in 2017 and being really struck by it, not realizing I was naive to kind of what was happening and how we got here. And a lot of the facts that come out of that article are being played out in the MDL litigation that you'll hear about. If you're looking for a longer read, the two books at the bottom are quite interesting. I've finished Dope Sick. They're similar books in talking about the background, but they kind of take different perspectives. I think actually the Barry Meyer book it's an expansion of the book that he published in 2001, and I think he was sort of the person that kind of broke the story, or the journalist that sort of broke the story about the Sacklers and Purdue Pharma. So I'm kind of interested in reading his expanded version, but those are some good background reading if you have the interest and desire. There's a dearth of resources for practitioners, lawyers, compliance officers, general public about what's going on, but the ones that we've listed here have been particularly helpful in kind of our endeavors. So the Health Lawyers, American Health Lawyers Association has a nice kind of white paper on challenges and initiatives. I included on this slide the Missouri State Board of Missouri State Medical Board has a actually very useful website with lots of resources about educating practitioners, that if you're someone who's sort of tasked with working with practitioners on this topic, it's not a bad place to go. They've really done a nice job there of kind of being very useful and having a lot of information. And then finally, I'll mention the Federation of State Medical Boards has some nice 50-state surveys about various various state board initiatives. So if you're working on a project with a couple different states involved, that might be a good starting point for your research. All right, so let's talk first about some laws and structures and kind of the regulatory framework that is going to affect the folks who are doing the actual prescribing. And then later you're going to hear from other folks, and Pari in particular, about how the prescribing prescribers how laws are being enforced against them, and sort of from the civil and criminal fraud perspective. So obviously, we're going to cover a little bit about state medical boards, state prescription drug monitoring programs, some limitations that are unique to the opioid abuse, or particularly affecting the opioid crisis sort of response in telehealth, and then give you some compliance tips or things to think about as you're walking through how to deal with this in your organization. Goes without saying, but there are 50 different approaches, actually more than 50. We're not just talking about state medical boards, but if you were, you'd have 50 different approaches to dealing with prescribing opioids and how to regulate them. And then certainly state nursing boards, state pharmacy boards are also taking action and have various rules and laws are being passed. So this is, we're not going to talk obviously about every state, but know that the laws are always changing. Minnesota has sort of a lighter touch in terms of prescribing regulation, but even Minnesota is changing. And so even if you, think what's going on, next session could bring new changes, or new guidance documents could be on professional board websites that could be useful to your organization and your practitioners. The states are really ranging in the level of regulation of prescribers. For example, you might just see a couple little guidance documents and nothing more from a state professional board. There's certainly boards that have required education. Some boards have adopted kind of their preferred pain management patient contract. That would be useful to know if your board preferred one form over another. And then there are certainly the states that have been more aggressive in terms of imposing limits on prescribing and dosage. So, for example, just a few months ago, Texas began to implement and enforce their 10-day opioid prescribing limit for acute pain. So for any practitioner who's prescribing opioids for acute pain, not chronic pain, now they may only issue a prescription for an opioid in an amount, up to 10 days, and there cannot be any refills. Instead, the patient has to come back in and see the practitioner to get the next 10-day supply. Ohio has something similar. They have a 7-day supply unless there's a specific condition documented in the medical record. Ohio also has some morphine equivalent dose limits that are more limiting than before for acute pain. And even if there isn't a regulation for acute pain, many boards have adopted guidance with respect to how to treat chronic pain. And I mention all of this because even if you're in a state where the law is not specific with respect to how many pills you can prescribe, the boards in their individual enforcement or review actions of licensed professionals are informed by the types of guidance and resources that they've gathered. So, looking forward, even if you don't have dosage limits, it would be useful for your doctors who are prescribing to know what particular guidance the board might have adopted or might be referring to on its website, so that you can kind of think about whether to adopt those guidelines and that thinking in your practice. Another vehicle that's been adopted by, I think, virtually all the states, at least 49, now maybe all of them.
And pending in D.C.
And pending in D.C., says Pari. So all of the states have some sort of state prescription drug monitoring program. And most of you probably know what this is, but for those who don't, it's a state-run database that collects data about controlled substance prescriptions that are written by doctors or other practitioners and dispensed by pharmacists. So there's a reporting requirement by dispensing entities, and then the purpose of them is so that or at least the main purpose, is to permit the authorized users, the practitioners, and then the pharmacists to be able to query it to see, for a particular patient, to see who's who's received opioid prescriptions in the past, how recent, from where, so that they can understand a little bit more about what's going on with the patient's prescription history, and certainly is useful in the case where the patient doesn't have that prescription history or is not being forthcoming about it. So that's about the only thing these all have in common. What's tricky about state prescription drug monitoring programs in terms of both advising clients but also from a public health response is that there are varying requirements in each state. So, for example, in Minnesota here, I think that there's only now a mandatory enrollment requirement for all prescribers. But the folks who are treating, let's see, a patient with an opioid use disorder in an opioid treatment program are the ones who have to query it. So it's not necessarily a universal use requirement. However, in a state like Arizona, I believe that every practitioner who prescribes a controlled substance has to review the preceding 12 months or so of the prescription drug history before they do that prescription. And similarly, the pharmacy, before dispensing, has to look at the 12-month history of that patient every time there's a new controlled substance for a new problem. So you're going to get different kind of query and use requirements in different states, similar to what must be reported and then the time frames. So some states require reporting by a pharmacy within, 10 days, some 2 days. And that's going to really make the information available to you vary state to state. The access, who has access piece has been an interesting question, kind of from a policy and a use perspective, a usefulness perspective. The main purpose was to allow prescribers and pharmacists see, what's going on with the patient. In some states, I believe law enforcement and the Attorney General do have access to the data, which raises an interesting question about whether we are aligned with the goal of destigmatizing substance use disorders and if we have law enforcement mining that data, but obviously there's competing policy perspectives there. And then I think in a couple states, for example, I think Kentucky, the data is used by the state boards to sort of track and trend and examine prescribing patterns for particular practitioners, which is useful, but not, prescriptions and that alone doesn't always give the best or the complete story of how a practitioner prescribes and whether it's appropriate. So that's kind of how the various ways we've seen people use state prescription drug monitoring programs. Pari will have more information on that. And then one sort of practice tip about this is there's varying requirements and sort of guidance around who may actually do the query. So, and in some states they have, it can be the prescriber, obviously, who queries, but there might be rules around who the prescriber may delegate that power to. So it isn't just like, in most cases, anyone at a hospital can go in and look at the state prescription drug monitoring program. There's some guardrails in many cases around who may do the querying and who may be a delegate. So be aware of what that might be. So as I said, because of these, because of varying laws, obviously, and jurisdictional differences, there are limitations on what we're able to accomplish with this. And certainly a lack of standardization among the state prescription drug monitoring programs. Many states have a lack of funding issue in that they have the database, but not the enforcement power because there's not funding to enforce. On a very practical level, it can be it can be an uphill battle to ask a practitioner to add one more item to their list of tasks that they're supposed to do with every patient, and that item being checking the state prescription monitoring program. I was just at a hospital client where I was able to see a demonstration of the EPIC medical record, of the integration of the state check right into the EPIC interface, so that there could just be one click and the data from the state program for that day, so updated daily, would be available to them. And to sort of hear the sigh of relief across the room of physicians was audible, because it was just making it a couple seconds faster for them to be able to get this valuable data, but not have to go outside to a separate database and do it. It was built right into their Epic screen. So kind of another tip is trying to think about how to make these tasks more simple or combine them for your prescribers. So I want to mention telemedicine here a little bit, and specifically prescribing via telemedicine. Kind of stepping back, we have been working with lots of organizations on how to work across state lines via telehealth to treat people generally, and then to treat substance use disorder patients. And so practice tip, when you're doing that and advising your client that way, you need to be, unfortunately, looking at the state law where the patient is. We don't have a universal telehealth compact scope of practice act, and so you're going to, for each situation, you're going to need to be looking at whether the practitioner who's treating the patient is qualified and has the appropriate registrations for that particular state where the patient is. And many states have telehealth registrations or limitations on what you can do for folks in the state. So that's sort of the general note here on treating patients across state lines. One, and similar to prescribing across state lines, you're going to need to be looking at the local laws. One sort of pain point that has come up with respect to, and that has been particularly difficult in the substance use disorder treatment space, is that federal law currently really limits the situations in which a practitioner can prescribe a controlled substance for a patient via telehealth. And that is the result of the 2008 Federal Ryan Haidt Online Pharmacy Consumer Protection Act, which is basically designed to sort of eliminate these online prescribing shops that had no relation to the patient, weren't even looking at them. So it did help with that, but what also happened is that they limited the scenarios in which someone can prescribe via telemedicine controlled substance. And so if you're using controlled substances to treat substance use disorders and you're doing that via telemedicine, you're limited to the situations basically where the patient, where you've either had you've conducted an in-person exam with your patient, or you have one of these practice of telemedicine exceptions. And those are basically, the exceptions are really only for the times that a patient is sitting in a hospital or a clinic that has a DEA registration. So what this doesn't allow is basically prescribing controlled substance, treat substance use disorders or anything for a patient who's sitting in their home, at work, or the school. And those places are where, we want to be able to reach patients for treatment purposes. So what happened was the legislation was supposed to, it did basically let the DEA create special registration rules. And so everyone thought the DEA would go out and kind of problem solve by having these special registration rules, and they didn't do that. And 10 years later, in the Support Act from last fall, the Support Act basically said, DEA, you have to promulgate special registration regulations, and we're hoping you do so with respect to treating substance use disorders. That was supposed to happen by a year from the Support Act, which was last October. Nothing happened. And so everyone's out there waiting for the DEA to come out and help solve this issue, and the DEA doesn't do anything. In November, just a couple months ago, everyone got really excited because the Justice Department put this posting up on their website saying, hey, look, we're going to issue special registration requirements soon. People got really excited, and now we're still waiting. So, and we've had several industry groups writing letters and trying to urge them along. So, compliance tips generally based on this little section. Seems obvious, but know your state board requirements, or the state board requirements that are regulating your practitioners at a minimum. Implement them into the practice and help educate your practitioners around at the very least the requirements. Also, whatever sort of guidance documents are informing your state boards. integrate the prescription drug monitoring program check into practice, certainly for folks who have to be doing it, and then maybe, you know, helpful even for folks who don't have to do it but are often prescribing opioids. Commercial payers can certainly take positions on how much they'll pay for opioid prescriptions. So, and as you know, commercial payers vary by commercial payer. So be aware of those policies from sort of a reimbursement perspective, and that can also affect the patient if things aren't covered. And then I would say generally be pairing up with a good clinician on how to go about reviewing and looking at practitioners' prescribing practices. We have a couple slides here about, quote, red flags in prescribing. And I put these up here with hesitation because not any one of these, and most of them even together, aren't necessarily examples of a prescriber with bad intent. Or necessarily even a bad prescriber, but there are certain clinical practices and there's data that can be examined to tip off really bad actors, of course, but then also folks who may be prescribing and they may be in a situation where they are overwhelmed. They have patients who are really pushing them for opioids and they, you know, are busy and there's no one else to go to. And so some of these kind of tips can be useful in helping people in their practice, as well as identifying people who are kind of off the rails. So not any one of these is going to be determinative, and it's extremely important to work with a clinician who knows what they're talking about. But some of these things are going to be useful in kind of at least examining where things might be going. So I won't go through all of them specifically. And I will mention that Pari is going to be talking about enforcement later and kind of the big data points that the enforcement bodies are looking at, whether or not those are good data points to review.
All right, so major national retail pharmacy chains like Walgreens, CVS, Rite Aid, and Walmart were named in the opioid MDL that we're going to discuss later on. Part of the lesson from this is that pharmacies are being identified as the gatekeeper between prescribers and patients. So in the opioid MDL and other litigation, pharmacies are facing claims that they failed to monitor suspicious orders and prescribers, and they failed to maintain effective controls against drug diversion, and that those failures have been a major contributing factor in the opioid crisis. So discovery in those cases is requiring production of records that show how many customers obtained opioids from the pharmacies and what safeguards were in place to ensure that those prescriptions were legitimate, medically necessary, and complied with the Controlled Substances Act. Just yesterday, CVS announced that it received a subpoena from the United States DEA asking for information about its handling of opioids and also asking for data on a large number of prescribers. So in addition to these criminal and civil enforcement actions, and Pari, again, we'll talk about more of those later, we've also seen state licensing boards taking actions against individual pharmacists who have engaged in diversion practices. So the obvious lesson from these claims is that the pharmacies should be ensuring that they have effective controls against suspicious orders and diversion. Pharmacies should have a compliance program. You should be following up on those red flags, taking corrective action, and self-reporting when appropriate. Also, under the 2019 Support Act, pharmacies are required to register with the DEA Suspicious Orders Report System. This is a database where you can report suspicious orders to the DEA. A suspicious order is one that deviates substantially from a normal pattern or orders of unusual frequency. You're also required to report any theft or significant loss of controlled substances within 1 business day of discovery. And that report is required regardless of whether or not the drugs were subsequently recovered and responsible parties were identified. We also recommend that pharmacists and pharmacies are watching for changes in their state relating to pharmacists prescribing opioid antagonists like naloxone, mandatory electronic prescriptions and consulting PDMPs, and reporting requirements for suspicious drug orders. I'm going to echo what Katie said about not relying too heavily on these red flags. Not one of them is determinative, but some red flags that have been identified to watch for in the pharmacies is whether or not there's been a high proportion of controlled substances that have been dispensed, whether insured patients are paying cash, whether customers are patients of known overprescribing physicians, and whether they're dispensing overlapping prescriptions. So up next, Katie is going to talk to us about EKRA.
All right. So EKRA is the nomenclature for the Eliminating Kickbacks in Recovery Act of 2018. This was part of the Federal Support Act that was passed in October 2018, which was legislation that broadly addressed opioid crisis matters. And so it's not a new, super new law, and we've certainly discussed it in previous webinars, but it is worth mentioning and digging into a little bit because it's very broad potentially in its application, and it's I think generally misunderstood, and in some ways not very publicized. There are certainly clients we have that are coming around that still don't know about EKRA. And there's a lot of debate about what should happen to EKRA and whether it should be narrowed in its scope. So generally, EKRA was designed to combat the type of bad patient brokering activities that were going on in the addiction recovery and the treatment facility industry. And so you may have seen a lot of those articles about sober houses kind of in bed with the treatment facilities and overpaying for patients and referrals and just kind of bad activity. And that's what we understand it was designed to address. Some people would say it was supposed to be broader than that, and in its final form, it is broader than just the sort of bad actor, sleazy activities that we all read about. So basically what this statute does is creates an all-payer prohibition against arrangements where there's remuneration being exchanged with recovery homes, clinical labs, and clinical treatment facilities. So this is different than your federal anti-kickback legislation because it isn't just related to services that are paid for by federal healthcare programs. It is an all-payer statute, so all commercial and non-commercial healthcare services. It's a criminal statute. There are monetary fines and potential imprisonment, or both, for each violation. So it's a hefty set of, every time there's a violation, you're looking at potential fine amount of up to $200,000. So kind of looking more specifically, as I said, the statute applies to, quote, healthcare benefit programs, which is defined very broadly. I've looked at this definition a lot of different ways and tried to make it not be defined broadly, but I am coming up short with how to narrow it. And the other interesting thing about this is that even though it was purported to be about addressing behaviors in the addiction, substance use disorder recovery space, by its language, it's prohibiting arrangements that cover referrals or orders for services like clinical lab services that aren't even necessarily substance use disorder related. So the broadest kind of expanse is with respect to the clinical lab services. Clinical labs obviously do not just exist for the substance use disorder treatment industry. So any arrangement that touches a clinical lab service is potentially affected by EKRA. The clinical treatment facilities term is defined as a non-hospital setting that is treating in some way substance use disorder addiction recovery service. So that's what a clinical treatment facility is defined as. So I think it's important in any scenario, kind of like I say with Stark, is to not do an EKRA analysis without the EKRA statute in front of you. The EKRA statute basically says that for people, it basically prohibits people with respect to, there's that healthcare services covered by that healthcare benefit program language, that broad language. Someone knowingly and knowingly and willfully soliciting or receiving any remuneration, so not just cash, directly or indirectly, in cash or in kind, in return for referring a patient to a recovery home, a clinical treatment facility, again, both of which are defined with respect to substance use disorder matters, or a laboratory. That's kind of the broader category there. Or paying or offering remuneration directly or indirectly to induce a referral of someone to one of these places. So not just inducing a referral for someone to substance use disorder treatment, but inducing a referral of someone to a clinical lab for any reason, or in exchange for them using the services of those three types of facilities. So that's the language of the statute. You can see how we get broad quickly. There are exceptions under EKRA, statutory exceptions under EKRA. I'm not going to go into them in detail, at least most of them. There's a discount exception. There's a personal services management contract exception that tracks the anti-kickback safe harbor exception. There's a co-payment, co-insurance exception. There's some FQHC narrow exception. And then there is room for the government to allow certain alternative payment models that may otherwise cause issues under EKRA to be okay under the statute. Where this has really caught up the industry is in the question of whether an entity that has folks who are salespeople for their clinical lab service, whether the compensation arrangements for those employees are now implicated by EKRA. The exception for employee arrangements doesn't appear to allow for commission-based arrangements. And that's important because under the anti-kickback statute, the employment safe harbor does allow for people to nevertheless have a commission-based arrangement program for their employed salespeople. What EKRA appears to do, possibly, I would say, look closely at the language, is possibly prohibit paying employees on a commission basis for lab sales. So that has gotten the industry up in a tizzy about whether it is the case that Congress intended for this to apply more broadly to sales people's commission arrangements. I don't think it's likely that the statute will be repealed, although I know that organizations like the American Hospital Association have been lobbying hard to get this statute narrowed or clarified, but I'm not aware of that success, and I'm a little skeptical that Congress would now go out and narrow a fraud statute. It just doesn't seem like that's the environment that we're in, but it's very possible. And certainly if you do know of any update to that sort of the inner workings of Washington and how that's going, I'd be very curious to hear it. All right, we're going to do some shuffling here since we have so many folks speaking, and Andrew is going to talk about Medicare.
Hi, everyone. This is Andrew Holm, and I'm going to cover some of the tools used by federal and state governments to expand the provision of Medicare and Medicaid-covered OUD treatment services. So the first topic I want to discuss relates to a new Medicare benefit for OUD treatment services furnished by an opioid treatment program, or an OTP. If you caught our December webinar, I covered this a little bit then, but it is a new benefit, so we'll briefly touch on it again here. So this benefit was effective 1/1/20 as a result of the SUPPORT Act. Prior to this new benefit, beneficiaries may have had to go out of pocket for OUD outpatient services if prescription drugs weren't covered under Medicare Part B or Part D. So this was designed to fill a bit of a gap in coverage there. The covered services are listed here, but include FDA-approved opioid agonist and antagonist medications, dispensing and administration of those medications, substance use counseling, individual and group therapy, toxicology testing, and certain intake activities and periodic assessment services. So enrolling as an OTP. OTPs are a provider type distinct from clinics or group practices with different requirements for enrollment. So a previously enrolled clinic or group practice will need to separately enroll as an OTP if it wants to provide and bill for OTP services. Multiple OTPs can't be grouped under a single enrollment, so separate OTPs must enroll separately. Some of the enrollment requirements, each OTP must have a current valid accreditation by an accrediting body or other entity approved by SAMHSA, which is the Substance Abuse and Mental Health Services Administration agency that oversees OTPs. In addition to accreditation, the OTP must have a current valid certification from SAMHSA for the program. The OTP would need to submit the CMS 855B application and pay the enrollment fee. Each OTP must also enter into a provider agreement. Again, we touched on this in December, but the 2020 physician fee schedule rule contains additional guidance for completing that enrollment application. Payments to OTPs are bundled. The methodology set forth in the regs, and the bundle covers OUD treatment services during an episode of care, which is a 1 week or contiguous 7-day period. CMS considered implementing a partial episode of care concept, but opted not to. So any services, the partial episode of care would have been reimbursed by at a lower rate. So with just the single episode of care, providers are paid for the full bundled rate regardless of the services provided during the episode. CMS will be monitoring for fraud and abuse as a result of that decision to not use the partial episode of care concept. But for now, if at least one covered service is provided, the full bundled payment's made. CMS also posted recent guidance to their website concerning beneficiaries who are dually eligible for Medicare and Medicaid. States have options there. They can pay the OTP provider for services provided and then recoup that money once the OTP is Medicare enrolled. Or states can decline to reimburse until the OTP is Medicare enrolled and then true up the payments at that time. Substance abuse counseling and individual and group therapy may be furnished via two-way interactive audio-video communication technology, assuming it's clinically appropriate and must be in compliance with all applicable requirements. Beneficiaries may receive the services from home. And OTPs, if they are providing telehealth services, must comply with all data security requirements, state rules, and state scope of practice rules. Another addition in the final rule for 2020 is CMS added 3 new HCPCS-G codes that covered office-based treatment, have been added as approved telehealth services. So next, let's talk a little bit about Medicaid. Medicaid is really important in addressing the opioid crisis. Based on data from the Kaiser Family Foundation, nearly 2 million non-elderly adults in the U.S. suffered from an OUD in 2017, and nearly 40% of those individuals were covered by Medicaid, which is more than double the share of all non-elderly adults covered by Medicaid. So individuals with an OUD are more likely to be covered by Medicaid than your average American. Utilization of treatment is low among this population, but those with Medicaid are significantly more likely to receive treatment than those with private insurance, which is interesting. Of the non-elderly adults with an OUD who received drug or alcohol treatment in 2017, more than half had Medicaid coverage. So just a little background to kind of put to put Medicaid's importance in this in context. So there's a couple strategies for increasing utilization of SUD or substance use disorder treatment services among Medicaid enrollees. Can increase the scope of coverage and services, and you can also increase enrollees' access to those services. So one way states have been able to increase Medicaid coverage is through state-by-state expansion. So the slide that's up now, I think it's current through last month. It's available at the Kaiser Family Foundation's website. The map is hyperlinked at the bottom there. And it shows which states have adopted the Medicaid expansion, which provides coverage to individuals with incomes less than 138% of the poverty level. The ACA also establishes minimum standard benefits for addiction treatment and expands federal parity requirements. So based on a recent study by the National Institute of Health, the ACA expansion has led to increased coverage of OUD services. Additional states have now covered individual and group outpatient, recovery support, and intensive outpatient treatment services, as well as short and long-term residential treatment and medication for their standard benefit plans. So 36 states plus DC have expanded the ACA. Some have also imposed restrictions or eligibility requirements, such as work requirements or maybe copays, but in general, the expansion has resulted in more folks being covered by Medicaid. So some other federal measures impacting Medicaid. The SUPPORT Act requires MAT, medication-assisted treatment, to be covered starting October 2020 through September 2025. This is important. MAT coupled with behavioral treatment services is the standard of care for OUD treatment. So this benefit will help increase treatment. States can be excluded from this requirement if they make a certification to HHS that implementation is not feasible by reason of a shortage of qualified providers or facilities providing MAT. Some other recent changes have expanded Medicaid coverage for inpatient or residential services at institutions for mental disease, or IMDs. These are generally excluded from coverage by the Medicaid statute, but a provision of the SUPPORT Act creates a state option from October 2020 through September 2023 to cover up to 30 days a year at an IMD. States must meet eligibility requirements to receive that federal funding. Some states have also utilized the Section 1115 waiver process to expand the scope of services offered to enrollees. If you're not familiar with this, CMS published a letter to the Medicaid directors in 2017 in connection with this initiative. It amended and replaced prior guidance from 2015, but still allows CMS to waive certain requirements so that states can test new or existing ways to deliver and pay for OUD and SUD healthcare services in Medicaid when those services are provided to patients in IMDs. And several states have expanded coverage via these waivers. So aside from increasing the scope of coverage or increasing the benefits provided, another way to help enrollees have access to care is providing access via telehealth. Some commenters think that just by simply expanding coverage, new providers will enter the marketplace, thereby increasing access to care, but a way that states can kind of affirmatively do this is to legislate and provide access through telehealth. It's a really, really interesting and developing area of the law. It's different in every state, and it's constantly changing. So the first is states can mandate coverage. They can mandate coverage of telehealth services provided or reimbursed through Medicaid or through private insurance. They can require payment parity, either again through Medicaid or private insurance, so that services provided via telehealth are reimbursed at the same rate as in-person services, which obviously increases providers' motivation and desire to provide telehealth services. Some states have telehealth acts that specifically authorize only certain types of practitioners to provide telehealth services. They don't necessarily prohibit practitioners from providing services via telehealth, but might only expressly authorize, say, physicians or psychologists to provide telehealth services that would be reimbursed by Medicaid or private insurers. But these acts often don't cover other key providers of OUD treatment services, social workers, or licensed drug and alcohol counselors. Some states might have site of service requirements, so those could require the beneficiary to, say, travel to a clinic or travel to a hospital, even though the provider might be located remotely. I think an approach that would increase access to care would be to allow, like was discussed earlier, the beneficiary to receive the services at home, at school, at work. Some states also require an additional facility or program certification or licensure. It's another administrative hoop to jump through, and may also impose additional site of service requirements, staffing requirements, other hurdles to jump through. And then state practice boards, this was mentioned earlier too. It's a very important piece of the puzzle. Even if laws are in place to authorize reimbursement for services, you want to have practitioners who are authorized to provide those services in any given state. We'll see often medical boards have provided guidance, but practitioners boards for other important practitioners may not have addressed the issue. So these are some of the hurdles that states have in place across the country that we're starting to see reduced, but hopefully that trend will continue. So I will turn it over to Chelsey now.
All right, I'm going to do a quick compliance reminder about privacy and health records before I turn it over to Margie to talk about state and local response. So with privacy, never forget about state law. It's easy to get focused on HIPAA, but you always have your state law, health and privacy laws that you need to be complying with. But I'm going to focus today a little bit on 42 CFR Part 2. So in addition to compliance with HIPAA and state privacy laws, some facilities are required to comply with the more stringent 42 CFR Part 2. So 42 CFR Part 2 only applies to Part 2 programs. So Part 2 programs are federally assisted individuals, entities, units within medical facilities, and personnel of general medical facilities that provide substance use disorder diagnosis, treatment, or referral for treatment. 42 CFR Part 2 is going to restrict the use and disclosure of substance use disorder client records that are maintained in connection with that Part 2 program. In general, Part 2 programs may not disclose any information that would identify a person as having or having had a substance use disorder unless that person provides written consent. There are a few exceptions for bona fide medical emergencies, court orders, and research. Part 2 also prohibits law enforcement's use of substance use disorder patient records in criminal prosecution against the patient. So in August, SAMHSA issued proposed rules to revise Part 2, which are intended to facilitate better coordination of care for substance use disorders, which will also enhance care for opioid use disorder. Comments were due back in October, and we're waiting to hear more. So with that, I'm going to turn it over to my colleague, Marguerite Ahmann.
Thanks, Chelsey. So I'm going to spend the next few minutes talking about policy and regulatory efforts that are happening at the state and local level. These are ones that go beyond just the prescribing efforts that Katie discussed and the Medicaid reimbursement and telehealth initiatives that Andrew touched on. We obviously have people from all across the country on this webinar, so we won't be focusing any time on specific state measures, but we'll try to pull out some of the trends or things to watch for within your state of kind of new and developing areas of regulation. So these include the regulation of pain clinics, funding and licensure of treatment programs, modifications to professional licensure regulations, and then a few other state policies. So a common early approach to the opioid crisis was to consider regulating high prescriber settings, and pain clinics specifically were seen as one of the sources of the influx of opioids in the market and a source of problem. People referred to particularly suspect ones as pill mills. And while it's much less widespread than the prescription drug monitoring program legislation that we talked about previously, numerous state legislatures considered enacting a regulatory structure around pain clinics. So there was a wave of these in the mid-2000s, and now there's a little over a dozen states that have elected to regulate pain clinics. The laws obviously vary from state to state, but generally require licensure or registration of facilities that meet that state's definition of a pain clinic. And those definitions typically get at facilities that provide and advertise themselves as providing primarily pain management services and prescribe controlled substances for that pain management. They often will exclude other types of pain management care that's like specific to cancer treatment, getting at the types of clinics that are that state regulators saw as truly suspect. The regulations typically dictate some ownership requirements, often requiring physician ownership by a physician who has essentially a clean record at both the state and federal level. They sometimes require specific training or additional credentials for either the physician owner or other management people at the clinic. So maybe board certification in a specialty area or training specific to pain management and prescribing practices. Certain states also impose specific prescribing and dispensing limitations for these regulated clinics. And then, like all regulated facilities, there are inspection, record keeping, and reporting requirements, which then help states monitor compliance and keep track of any suspicious prescribing practices of specific clinics. It seems like over the last few years, the legislation around pain clinics is slowing, but we do see a handful of bills up every year. I know there was just a recent one for a licensing regime in New Jersey. And then in other states where they don't have specific regulation of pain clinics, these, of course, remain under the purview of state medical boards and the prescribing guidelines and other restrictions that Katie talked about previously. All right, needless to say, state responses vary greatly too when it comes to the amount of funding that they're dedicating to opioid-related response, as well as how they are using or directing those funds. Funding greatly impacts the amount of effort as well as the kind of innovation that a state can apply towards its opioid treatment efforts. And the most hard-hit states that Chelsey highlighted at the beginning of the presentation tend to rely heavily on federal funding to address the service gaps in those states. And the federal government has made funding available to states through a variety of agencies and programs. There's funding available and grants available through the DOJ, CMS, the National Institutes of Health, the Department of Labor, but the Substance Abuse and Mental Health Services Administration, or SAMHSA, is the agency in charge of administering the two primary state program grants for opioid treatment. That is the State Targeted Response and the State Opioid Response Grants, which have been given out to states over the past several years, and it's amounts in the billions of dollars of funding that have been provided to states. And these are aimed at increasing access to treatment and recovery services with a particular emphasis on medication-assisted treatment, or those MAT programs we've been talking about. And And then states have, access to those federal resources and support, but then they're able to kind of shape policy at the local level. And then because a lot of states have their behavioral health systems organized by county, the states are then responsible for allocating in some equitable manner those funds to the counties, which in theory provides kind of further targeting of those funds and some innovation to happen at the local or county level. Another trend around the financing of treatment is to integrate or carve in treatment services to Medicaid managed care contracts. Historically, Medicaid programs have often excluded or carved out substance use disorder services or opioid use disorder services from their managed care contracts and have delivered those programs kind of under a separate program, separately financed, and in a separate fee-for-service system. More and more states are choosing to incorporate those into their kind of existing package of Medicaid services, which provides some better access to these services, but does come with some operational changes, administrative changes in to how these providers are enrolling in state Medicaid programs. So it's just something for providers to be aware of to make sure that they are keeping up with how the state is choosing to provide those services to their constituents. All right, another common area of change that we're seeing at the state level is in treatment program licensure. So many states are reviewing their current substance use disorder treatment program or facility laws in order to conform with a lot of the other policy changes that are happening within the state, or modernizing their existing laws to contemplate the newer treatment modalities that we're using, or more continuum of care models, which is what we've done here in Minnesota, or even just to update the language used. So you're seeing a lot of changes just to revise references to chemical substances to being substance use disorder, and kind of modernizing the language. Other updates that we're seeing are to clarify which programs require licensure, whether a program funded through the state is going to be subject to the same licensure requirements that a independent and private treatment program would be subject to. There are updates regarding what kind of required assessments are needed, which individuals are authorized to provide care in these facilities, telehealth, as Andrew talked about earlier. We're seeing more coordination of residential programs across agencies. So when there were 2 different state agencies that were involved with licensing of those facilities, more states are trying to coordinate that process. And then peer recovery support services are a new area that we're seeing being integrated into the state licensing laws as well. Another area of licensure is around office-based opioid treatment programs. So this is treatment provided by clinicians within their regular medical practice and in the primary care setting. So it's thought that the provision of opioid treatment in this setting will help expand access to treatment and also provides certain individuals with a more private experience for getting care. But then these physician offices are typically carved out of the treatment program licensure regimes, so they don't typically need to get a substance use facility license. And this is causing some concerns in certain states about the quality of care and the risk of diversion in these facilities. And so certain states are starting to regulate those practices of physicians offering office-based opioid treatment. So again, these regulatory regimes are going to vary greatly from state to state, but they typically require some sort of licensing, payment of a fee and regulations around staff training and the types of services that can be offered, and sometimes limits on dosage or formulations. So those are all things that you want to be aware of in your state, and make sure that you know what's coming down the pike on those. All right, so on to professional licensure. The substance use disorder workforce is incredibly broad. As I was thinking about this, I think it's broader than any other area of healthcare that I've seen. You've got the professionals that, the healthcare professionals that work in all of the typical medical environments, physicians, PAs, nurses, psychiatrists, but then you have a whole additional set of professional counselors who are either licensed or certified in the state. So I have a few of them up here on the slide: alcohol and drug counselors, marriage and family therapists, professional counselors, other substance use disorder counselors, where the titles and the credentials vary from state to state. There's really no standardized classification of these credentials, you know, it's really a state-specific research matter. And then a newer category are peer recovery support personnel. And these individuals, they tend not to be licensed at the state level, but they sometimes are subject to specific requirements imposed by either the program licensing statutes or regulations within the state, or payer requirements or Medicaid requirements, in order to dictate the credentials of those support personnel. And so, similar to the approach that states are taking with respect to the treatment facility licensure, many professional licensing boards are also taking kind of a fresh look at their practice acts to modernize the language used around substance use disorder, and to clarify and expand kind of licensure categories specific to those who'd be involved in opioid treatment. Many of the specific substance use counselor licensing regimes were designed a while back, and when it was contemplated that it would be more of an apprentice type model, more of a learn on the job type model, and so a lot of professional licensing boards are now taking a look and trying to revise to reflect more updated educational and academic credentialing requirements, and then more integration with other behavioral health competencies, and making sure that the educational requirements are kind of up to current standards. There are also 2 national certification bodies, each with a different set of standards and titles. There have been efforts over the past couple decades to try to standardize those titles and the certification. To date, none have been very successful, but I think we will inevitably see more of a push to do that, particularly in light of the desire to provide more of these services via telehealth and the difficulty it will cause of having these professionals operate on a multi-state basis or try to move across state lines. So obviously I haven't been able to cover all of the state policies. I did want to highlight just a few other things that states are doing in their efforts to combat the opioid crisis. And, you know, I think this is somewhat obvious, but I found it very interesting, the number of articles that are out there now that we're in kind of a second phase of implementing some of the first efforts to combat the opioid crisis, that states are taking the data, taking the programs that they have put in effect, tracking all of those, and using data analytics in a more sophisticated manner to come up with new ways for a kind of second generation of programs. The mini EKRA legislation point on here, so we often refer to mini anti-kickback statutes or mini Stark statutes that are kind of mirror images of what is in the federal legislation, but at the state level. And we are seeing the same thing with EKRA, although many of these predated the federal legislation, but there are patient brokering laws aimed at getting at the same type of conduct that Katie was talking about earlier in Florida, California, Utah, and New York. And so those are all things for you to be aware of. And let's see, the last thing here is specialty drug courts. This was just a comment that most states also are looking at ways to kind of divert people suffering from opioid use disorder out of the general path to incarceration and put them in diversion programs instead. With that, I will turn it over to Pari, who's going to talk about the more exciting enforcement efforts.
Hi, I'm Pari McGarraugh. I'm going to spend a few minutes talking through some recent developments in criminal and civil enforcement. In civil enforcement, I'm including sort of administrative enforcement. The front end, I should say that enforcement comes in a lot of different flavors and forms in this area. This area is subject to overlapping regulation by states and by the federal government and by different agencies at each level. So you can be talking about licensing board actions by Board of Medicine, Board of Pharmacy, Board of Nursing at the state level, or a program licensure sort of consequence. So those are state level issues. At the federal level, you can see DEA action. You could see Medicare recoupment sort of action if services aren't, or in this case, probably, prescription drugs were not seen as medically necessary. You could see Medicare recoupment or fraud allegations, either civil or criminal. And then at both the state and federal level, there are sort of corresponding criminal offenses. And so when we talk about enforcement in this area, it can come from a lot of different directions. The other thing to keep in mind is that enforcement has a ripple effect in this area. So if you have one set of problems, it can cause other sets of problems. So for example, licensure action at the state level can cause an exclusion action, which can cause you to get kicked out of Medicare, which can cause a Medicaid recoupment. And so if you find yourself in these situations, having some guidance that, by an attorney or other sort of qualified person to guide you through the ways that this could pop up again. If you're interested in the DEA's opioid enforcement efforts, the OIG, federal OIG, put out a report to Congress this past fall that's super interesting. Feel free to shoot me an email and I'll send you a link to it. One thing that I will say is I have been schooled by a listener, and I should not have trusted this OIG report when it told me that all 50 states have prescription drug monitoring programs. One of you tells me correctly that Missouri does not. You are completely correct. Missouri does not, based on my Googling as I sit here. In fact, what Missouri has is a voluntary program joined by localities that covers about 84% of the population of that state. So anyway, that's really interesting. Another thing that stuck out for me about the DEA's, or this report about DEA enforcement, is that the OIG reports in sort of a critical tone that DEA has not been as aggressively using its most powerful enforcement mechanism, the immediate suspension order, in recent years. Implementation of that particular type of order is actually down since like 2013. OIG links that to a 2013 court decision in which a judge took the DEA to task for imposing this kind of an order without having the evidence lined up to prove it. The OIG describes this in a way that makes it seem like the DEA should be more aggressive. As a defense attorney, that puts my stomach a little bit in, not because we would prefer that the government not take sort of really aggressive action in the absence of evidence that it's a good idea. So anyway, this is a fascinating report if you're looking for some light bedtime reading. So I'm going to talk first through some themes and trends, a couple of federal enforcement initiatives. I'm going to walk through a couple of examples of recent actions, and then do a little bit of prognosticating with surely limited accuracy on what we think is next. And then I'm going to pass it over to my colleague Chelsey, who is going to update us on the opioid multi-district litigation, which is currently pending in federal court in Ohio. All right, so themes and trends. The first trend will not be a surprise to you based on what we've already said, which is data-driven enforcement. Katie talked to us about the state prescription drug monitoring programs, and those are being explicitly used by federal enforcement agencies to identify aberrations in prescription drug prescribing sort of patterns. So these sort of red flags that we've talked about. And then there's also been work to match those data sets with claims data from Medicare and Medicaid, which if one data set is powerful, two data sets linked together are a lot more powerful. And so these analytics are getting sort of increasingly sophisticated. Note that the red flags are only as troubling if you choose the right comparator, right? So a doctor who treats mostly cancer patients who has lots of prescription drugs for opioids is maybe less concerning because they have patients who are in a lot of pain than a physician in a different kind of practice. So that would be sort of one thing to keep in mind, and I don't know that we are necessarily getting good comparators on the government analytics side. There has been an express focus at the federal level to coordinate between agencies to match up data sets and align enforcement priorities. The DEA has also been coordinating with the state prescription drug monitoring programs to try to get access to that data. States have varying approaches to how much they are willing to cooperate on that, and at least according to the DEA report, which I now know is suspect in its accuracy, Vermont apparently refuses to share any data at all with federal enforcement agencies, even in the presence of a subpoena or warrant based on the state statute. Another trend is there is increased funding. Andrew and Margie talked about increased funding for treatment and for the provision of service. There is also increased funding for prosecutors. So they are hiring people to prosecute. Another trend is the focus up the food chain and focus up the supply and distribution chain. So there have been a number of high-profile actions, charges filed against people up the food chain, CEOs, owners, as opposed to against the prescribing physician, or against sort of a civil enforcement action against the company. And then there's also a focus up the supply chain. So we used to think about this as bad acting doctors and then sort of bad acting pharmacies, but we're moving back into the supply chain, distributors, manufacturers, as the sort of government takes a more aggressive approach to dealing with this serious public health issue. Another trend that we're seeing is things that we would have thought and expected to be dealt with on a civil basis, 10 years ago, are now more increasingly likely to be charged criminally. I'm going to have to go faster than I want to, guys, sorry. All right, here's a federal enforcement sort of task. I guess this is a unit, not a task force. The next one's a task force. That was announced by DOJ in August of 17. There's a link to the press release if you are interested in what Jeff Sessions has to say about it. This is the Opioid Fraud and Abuse Detection Unit. This is focused on data analytics. So this is the red flags. This is prescribing and dispensing patterns that are outside of the norm. This is looking at DEA registration data and reporting data in combination with Medicare claims data. Patient outcomes, so they're linking patients who overdose to particular prescribers and looking at the length of time in between prescriptions and overdoses and trying to develop patterns. And then there's some demographic analysis. So they're looking for pharmacies where most of their patients travel more than an hour because that is a sign of a bad actor. Whether when patients are very young or very old, because patients tend to be more vulnerable, things like that. This program, this initiative, also funded additional federal prosecutors who are focused on healthcare fraud issues related to opioids, so pill mill schemes and pharmacies. So this would be probably prosecuted under the healthcare fraud statutes, Medicare fraud statutes, or I guess civilly enforced. There's a geographic focus on this, and this is matched up to hotspots for opioid deaths and opioid use issues. These should be familiar to us. These are the same states that largely showed up on Katie's early slides. The DOJ says that they have received requests from other these are federal judicial districts, asking to be included in the program. So this program is likely to grow, assuming they can get the funding, which, given the bipartisan nature of this particular public health crisis, they probably will. Another federal initiative is this Prescription Interdiction and Litigation Task Force. This is announced in February of 2018. This is the stated purpose of this is to aggressively deploy and coordinate all available criminal and civil law enforcement tools to combat the opioid epidemic. And this group has a focus on sort of back up the supply chain in a way that is sort of a new development. So manufacturers, pharmacies, distributors, pain management clinics, drug testing facilities, and individual physicians. This task force has an explicit focus on coordinating with the state authorities to encourage data sharing and to align enforcement priorities, including prosecutions. And they've also been tasked with evaluating and recommending regulatory and statutory changes, so there's sort of a policy function of this group also. All right. There are a bunch of other sort of both federal and state initiatives. DEA did a 45-day burst enforcement. I mean, there's a bunch of this stuff. If you Google it, you'll be swimming in information about it. I just selected those two to sort of illustrate the focus. I'm going to walk through a couple of examples of recent, semi-recent enforcement actions. This first one was announced just a few weeks ago on January 27th. DOJ announced a settlement with Practice Fusion, which is an EHR system provider. As part of the settlement, Practice Fusion agreed to pay an absolutely incredible $145 million to resolve both civil and criminal investigations. These were all related to the anti-kickback statute, so both civil and criminal. Criminal fine is $26 million, $1 million in forfeiture of criminal proceeds, and $118 million to settle the civil claims. Practice Fusion supported a free ad-supported electronic medical record. Company admitted as part of the settlement that it solicited and received kickbacks from an opioid manufacturer to design the EHR system in a manner that could influence physician prescribing patterns for pain medication. Government alleged that opioid manufacturers were allowed too much role in designing clinical decision support alerts in the program, so little pop-ups that would tell you more about, it would sort of prompt the physician to do the next thing, and that these alerts were focused on chronic pain management treatment. In some cases, the government alleged the manufacturer actually wrote the copy for these alerts and made recommendations about what guidelines should be used to trigger alerts. Government says these guidelines did not meet acceptable medical standards. These alerts were in place for, looks like, just a little less than 3 years, and apparently were triggered about 230 million times. Practice Fusion, not surprisingly, has announced a more robust compliance program in the wake of this settlement.
Oh, Pari,
Yeah.
quick question. Does the practice fusion case involve EKRA at all?
I don't believe so, but I'd have to look at the underlying documents. I believe this is an anti-kickback statute case, sort of on a garden variety kickback theory. As a sort of very boring aside, I wonder how you would prove causation, how you would prove that the alerts caused anybody to prescribe anything. I guess you try to do it statistically. There's sort of mixed case law on whether that is a thing that you can actually do as a matter of evidence. Here's another pending case. So this is Dr. Thomas Keller. He's a physician in California. He is, as of last week, in trial for murder after 5 patients overdose. He was charged with second-degree murder. This is obviously not yet fully resolved, but he is being tried on 4 counts of second-degree murder and 1 count of elder abuse relating to a patient who later died in connection with excessive levels of prescription drugs. The facts as alleged are pretty egregious. He allegedly gave patients both written and fax prescriptions, which allowed them to fill at 2 different pharmacies, which, you know, may show that he knew that what he was doing was the sort of thing that you'd want to do 2 different places to conceal. He is accused of keeping a diary in which he said sort of unflattering and inflammatory things about his patients, like calling them drug addicts. And he's also accused of prescribing drugs in dangerous combinations, what they call the holy trinity of anxiety medications, muscle relaxers, and opioids. Dr. Keller's lawyers are arguing that his patients, these particular patients, committed suicide. There's also a jury trial scheduled for June on Medicare fraud charges related to sort of similar fact patterns. All right, this one is a little bit complicated, but we'll do it super fast. Rochester Drug Cooperative is a drug distributor, and the company and 2 of its executives were charged with conspiracy to violate the Controlled Substances Act and failure to submit reports under the Controlled Substances Act. The company entered a deferred prosecution agreement, and they paid a $20 million fine, and it agreed to 5 years of close monitoring. The facts of this case are basically that the distributor was aware that its pharmacy customers had abnormal patterns and failed to report this to the DEA, and also did not implement controls to prevent this. It sounds like the company maintained, or at least the government alleges that the company maintained its own internal list of trouble pharmacies, but did nothing about it and continued to distribute to them. Of note here, the chief compliance officer was actually charged with 2 felonies and pleaded guilty and cooperated with the government. Charges are still pending against the former CEO of the company. This last one I'm going to talk about is a settlement reached in May of 2018 by the Effingham Health System. The health system agreed to pay $4.1 million to resolve claims that it failed to provide effective controls that would prevent and detect tens of thousands of doses of opioids being diverted. The health system cooperated with this investigation and made voluntary changes. This is different than the cases that I've talked about before because the facts of this are not as sort of alarming in the same way. This is a failure to detect. To me, this is the case that makes my gut clench up a little bit, because I think we sort of intuitively know that you shouldn't ignore things that you know about, but this is like, should you detect things? And so this counsels for a strong compliance and monitoring program. All right, things to look forward to. More powerful uses of data as data sets get linked together, analytics get better, and the enforcement agencies get better at working together. More funding. The 2021 proposed federal budget, which, I mean, obviously subject to adjustment by Congress, is looking at, I want to say, almost $380 million earmarked for opioid enforcement. Maybe an increase in DEA administrative enforcement, as, you know, sort of on the theory that the OIG is pushing them to do that. And then maybe we're going to get 30 seconds of update on the opioid multi-district litigation from Chelsey right now. Oh, I forgot about this slide. One just sort of very brief point is in this sort of ripple effect issue. Healthcare practitioners are affected by substance abuse and addiction issues as, you know, like everyone else. And so if you're dealing with those issues, beware of the ripple effects. If your employees are dealing with these issues, beware of the ripple effects. What starts as a licensing action can get a bunch of different places really fast. So you want to make sure that you're paying attention to the way one action will trigger another.
All right. One of the cases that we're watching with interest is the opioid MDL that we've mentioned a few times today. So when this case started off, it involved plaintiffs from 30-plus states and nearly 1,500 cities and counties. And the defendants were opioid manufacturers and distributors and pharmacies, including Purdue Pharma, Cardinal Health, CVS, and Rite Aid. So the plaintiffs alleged that the manufacturers of prescription opioids grossly misrepresented the risks of long-term use of those drugs for persons with chronic pain, and distributors failed to properly monitor suspicious orders of those prescription drugs, and all of this contributed to the current opioid crisis. So back in October, the drug distributors, including McKesson, Cardinal Health, and AmerisourceBergen, which distribute about 90% of all the medicines to the pharmacies, hospitals, and clinics in the United States, agreed to pay $215 million to the 2 Ohio counties that brought the lawsuit. Recently, the pharmacies that are still in the case lost their motion for summary judgment on the plaintiff's claim that the pharmacy's failure to stop opioids from being diverted for illicit purposes created a public nuisance. The judge ruled that the counties had shown evidence that CVS Health Corporation's system for suspicious orders was makeshift, haphazard, and ineffectual. As an example, CVS, between 2006 and 2009, had no formal written procedures to identify suspicious opioid orders and instead relied on employees' gut feelings to identify orders that were too large. Similarly, Walmart had no written procedures for monitoring suspicious orders until 2011. And while Rite Aid Corporation had a list of suspicious prescribers, it took no steps to determine whether orders from those prescribers were suspicious. The trial keeps getting pushed back. It's already been to the Sixth Circuit a few times and is there right now on a question about a negotiation class. But the bellwether trial regarding the 2 Ohio counties against the pharmacy retailers is currently scheduled to begin in November. In an interesting turn of events, the major drugstore chains filed a suit of their own last month, arguing that physicians and other healthcare practitioners who write opioid prescriptions should be held liable for contributing to the opioid crisis, not the pharmacists. The pharmacies are arguing that they only have a limited role in making sure that prescriptions are legitimate and that they should not be responsible for second-guessing the doctor's prescription. The drugstore companies in their complaints did not name individual doctors and only referred to them as John and Jane Does 1 through 500. So we're going to be continuing to watch this and other developments as we help our clients continue to navigate these issues. And with that, that's the end of our substantive content. I think we have a couple of questions that came in, but just wanted to let you know that if you have the LinkedIn app, you can use that to scan our QR codes and connect with us on LinkedIn.
And in the interest of time, I think we'll reach out to the folks who ask questions. I think they're really specific. And if you do have any questions later on, please feel free to reach out to any of us. Thank you for the going along with our grand experiment of a 90-minute webinar, and maybe we should have made it 100 minutes. We really appreciate you listening, and we'll see you next month.